Legal aspects of insurance. The objectives of this lecture, by the end of it, you should be able to explain the concept of insurable interest and discuss the concepts of indemnity and subrogation. Insurable interest. Insurable interest is when an insurance contract is legally binding only if the insured has an interest in the subject matter of insurance, and the interest is in fact insurable. What constitutes an insurable interest? Ownership, in some cases leases, secured creditors, not general creditors, legal liability, care, custody, and control, and in life insurance, it exists for the person voluntarily insuring one's own life. Others must have an insurable interest. When must the insurable interest exist? Well, for property insurance, it must exist at the time of the loss. If, for example, you had a homeowner's policy and you sold the home and the new owner had a claim after you closed escrow and title had transferred, your policy would not cover that loss because there was no more ownership interest in the home after you closed escrow and it was sold. In life insurance, it's a little different. It must exist at the inception of the policy. Continuing insurable interest is not necessary. The principle of indemnity. This is when the insurer agrees to pay no more than the actual amount of the loss. Stated differently, the insured should not profit from a loss. And now this principle of indemnity has two purposes. One is to prevent the insured from profiting, and two, to reduce moral hazard. Underlying the principle of indemnity is the concept of actual cash value, ACV. No matter how much insurance is purchased, the amount recovered is limited to the actual loss. The actual cash value is determined under one of the following methods: the replacement cost less depreciation, fair market value, and the broad evidence rule. On actual cash value, we take replacement costs less the depreciation to come up with the actual cash value. So replacement cost is the cost to repair or replace with like kind and quality of material, and depreciation, it's a measure of betterment. So, an example, Susan's favorite chair was completely destroyed by a fire. She purchased the chair several years back, and it's 50% depreciated. A similar chair today sells for $1,000. Susan would receive $500 from her insurance company, equal to the $1,000 replacement, minus the $500 depreciation. The fair market value method. An example of this is estimating the price a willing buyer would pay a willing seller in a free market. So a building valued at $170,000 based on the actual cash value had a market value of $65,000 due to a poor location in a deteriorating neighborhood. Broad evidence. The broad evidence rule method incorporates many factors which are listed below. So it means that the determination of the actual cash value should include all relevant factors that an expert would use to determine the value of the property. Some of those are listed here: original cost, cost of restoration or replacement of the building less depreciation, the age of the property, the economic value of the property, the condition in which the property is maintained, the income derived from the building's use, the property's location, the degree of obsolescence, both structural and functional, the profit likely to accrue on the property, the material of which the building is composed, the market value, the opinions of value given by qualified witnesses such as real estate appraisers and economists, the potential gainful uses to which the building could have been put to use, the building's fair rental value, and any other factors which may shed light on the actual value of the building to the insured. Some exceptions to indemnity are valued policies, replacement cost policies, and life insurance policies. On a valued policy, it'll pay the face amount of the insurance if a total loss occurs. They're typically used to insure antiques, fine art, rare paintings, also antique classic automobiles. The insurer agrees on the value of the property at the time the contract begins, and in the event of a total loss must pay the face amount of the property, or on the policy. Using an antique classic auto, for example, a client who has a 1969 fully restored Camaro, Typically, the auto policy will be actual cash value, but for a unique vehicle like that that has been fully restored and is regarded as a classic and meets the insurer's definition of an antique or classic, a stated value can be established when the policy is taken out. Typically, the underwriter will also want some documentation to justify that value too. On replacement cost policies do not deduct for depreciation in determining the amount paid for a loss. Replacement cost insurance is based on the recognition that payment of the actual cash value can still result in a substantial loss to the insured because few people will budget for depreciation. Most commonly, replacement cost is seen in homeowners policies. If your home is 30 years old and it burns to the ground, if you have building ordinance coverage, not only is the building rebuilt to how it was, but it's rebuilt to current code, which typically will be much better than how it was. Code is constantly changing over time for buildings, and so as a result, replacement cost comes into play on homes because it has to in order to reoccupy the home after a major fire. On life insurance policies, there are a third exception to the principle of indemnity. A life insurance contract is a valued policy that pays a stated sum upon the death of the insured. Now, if insurance did not exist, really the only way to recover would be, if you're injured by some negligent party, would be to sue them and hopefully recover in a court of law for your injuries, the economic value of them. Now, in subrogation, one who indemnifies another loss is entitled to recover from any liable third party. So, the injured insured, let's say their property is damaged, for example, their car. The insurer will pay to fix the car, but then the insured's right of collections are transferred or subrogated to the insurer so that they may collect from the negligent party for whatever they paid out for that loss. So again, on subrogation, if the insured collects indemnity under the policy and the loss has been caused by the negligence of some third party, the right to collect damages from the negligent party must be relinquished to the insurance carrier. Some of the impacts of subrogation is that it reinforces the principle of indemnity. You can only collect once for a loss. It holds rates below what they would otherwise be because of the salvage factor. Salvage is when the insurer has a partial recovery in the disposal of the damaged property, and that helps reduce the overall cost of the loss. It also places the burden of loss on those responsible, typically from negligence. The insurer will get a judgment against that party. They will recover from either that negligent party's insurance company if they have insurance, or the judgment will go against their assets if they do not have insurance. Subrogation does not exist where the principle of indemnity does not apply. For example, life insurance. If a client were to be hit by a drunk driver and the life insurance company pays out $1 million because the client had a $1 million life insurance policy in place, the life insurance company does not pursue collection against the negligent party. So subrogation is always waived for an insured, and if an insured violates or destroys the insurer's subrogation rights, the insured may forfeit collection rights under the contract. The insured is entitled to subrogation dollars only after the insured is fully collected for the loss. On that last point, here we go. On the last point, what that means is, let's take an auto claim, for example, a collision where the insured has a $1,000 deductible. The car is worth $10,000. The insurance company pays out the value of the car minus the deductible, so $10,000 minus $1,000 being $9,000, and then pursues collection against the negligent party. Any first dollars recovered will go towards reimbursing the insured their $1,000 deductible. Any money received after that will go towards reimbursing the insurance company for the $9,000 that they paid out. Continuing on, we just kind of went over this in the examples. You could take a look at it it's a flow chart on subrogation. So in summary, we have discussed the insurable interest, the principle of indemnity, and the principle of subrogation. Thanks for your time.